Conventions and controls. In this video, we'll discuss CITES versus goods subject to sanitary and phytosanitary controls. But first, a question. What is a legal convention? Okay, great. This is an agreement, usually between states, countries, trading areas, etc., for example, the Common Transit Convention, CTC. And conventions set out basic principles of one sort or another, that are, often passionately, believed as true or correct, across borders, well at least by all parties signed up to the convention. On top of this, the convention also includes procedures and guidelines, detailing how these principles may be upheld. Often very complicated, but conventions are not enforceable in their own right. Instead, for particular areas, where enforcement is needed, the states or territories that have signed up to a convention, take home the final version of the principles, guidelines and enforcement procedures of a convention, and use them as a template, or framework, to implement domestic legislation, in their own countries or territories. In this way, the principles of a convention, become enforceable by law at a national level. Convention principles and procedures can also be implemented as legislation, for a wider trading area. For example, conventions such as the CTC and CITES are accepted as part and parcel of EU membership. We introduced CTC elsewhere. But what is CITES? CITES. The Convention on International Trade in Endangered Species of Wild Fauna and Flora. From the CITES.org website, CITES is an international agreement between governments. Its aim is to ensure that international trade in specimens of wild animals and plants does not threaten their survival. A draft version of this convention was produced in 1963 by the International Union for Conservation of Nature, also referred to here as the World Conservation Union. The first widely adopted version came about 12 years later, on the 1st of July 1975. CITES is an international agreement to which states and trading areas adhere voluntarily. States that have agreed to be bound by the CITES Convention use CITES rules as a template or framework from which to create domestic legislation enforceable by their own national laws. And 183 countries and trading areas have signed up to CITES, including all EU member states and the UK. And that's nice. So how has Brexit ultimately affected trade in CITES goods? If we jump back to our UK border model, we see information on how UK CITES exports are affected, on page 79. But also, we can search for page 25, for information on CITES imports. For imported goods, covered by international conventions or other types of commitments. So let's duplicate this tab and make both pages easily accessible for a moment. And we see, for imports, endangered species of wild fauna and flora, CITES. At the end of the transition period, movements of species controlled under CITES between GB and the EU will need to comply with the same arrangements as those in place for movement between the UK and non-EU countries. This pretty much means that the UK will activate its own implementation of CITES from January 2021, as opposed to following the EU implementation. But this also means that imported species listed in CITES, or their parts or derivatives must be accompanied by valid CITES documentation, such as an import permit from the UK and an export permit from the exporting country. And each particular type of CITES product must enter the UK via a customs office, designed to handle and inspect that particular type of product. And we see that a CITES office is referred to as a POE, down here. You might also see mention, in the literature, of Customs Border Control Posts, BCP, or Border Inspection Posts, BIP. And my understanding is that, where a POE relates to CITES goods, BCPs and BIPs refer to SPS goods. Otherwise, the similarities describe customs offices equipped for a variety of specialist purposes, for example, plant and animal checking and perhaps even for processing certain controlled goods. And if we pause for a moment, page 79, we can understand that something similar applies for exports of CITES products too. Exports of endangered plants or animals. We see these must also be accompanied by valid CITES documentation, such as an export permit from GB and an import permit from the country where the goods are headed. And once again, these must leave via a custom office that is sufficiently equipped to process the export. And available on both pages, a list of CITES designated points of entry and exit, POE, is available online. Skipping over to imports. And at all times, all CITES permits, declarations, etc. need to be presented to the authorities at the CITES designated points of entry. Don't break the law, or you could be liable to a prison sentence of up to 7 years, or an unlimited fine, or both. And that's nice. And for both imports and exports, we see species covered by CITES are listed in the UK under one of 4 annexes to the Wildlife Trade Regulations, according to the degree of protection that each species needs. Click on that. And taking a quick look, we see mention of the CITES Basic Regulation, Implementing Regulation, Permit Regulation, and Suspension Regulation. We also see down here an EU Enforcement Action Plan, which informs EU member states regarding the enforcement of the EU Wildlife Trade Regulations. And that's great. Jumping back, the exact import controls that apply are determined by the appendix the species are listed in. And indeed, traders can check their species info from here. Species plus. Could be useful for applications. And sites permit applications for import and export, are processed by the Animal and Plant Health Agency, APHA. Get forms and guidance from here, but do contact APHA first to sort out any specifics. Interestingly, we also see an overlap with sanitary and phytosanitary requirements. Additional welfare and sanitary and phytosanitary requirements. What is this? We see both imports and exports of plants, animals and products listed under sites may also be subject to sanitary and phytosanitary controls, which may require extra paperwork and border control rules. That's great, but what is it? Okay. Phyto, P-H-Y-T-O, from ancient Greek, meaning plant. Sanitary and phytosanitary measures, rules relating to human and animal health, as well as plant food health-related issues, commonly referred to as SPS measures, protect humans, animals, and plants from diseases, pests, or contaminants. But more than that. Quickly jumping over to understanding the WTO Agreement on Sanitary and Phytosanitary Measures. This is the agreement on the application of sanitary and phytosanitary measures that sets out the basic rules for food safety and animal and plant health standards. This is one of the cornerstones of the World Trade Organization rules that countries sign up to. The Agreement on the Application of Sanitary and Phytosanitary Measures, the SPS Agreement, entered into force with the establishment of the World Trade Organization on the 1st of January, 1995. It concerns the application of food safety and animal welfare and plant health regulations. That's great. But what does all this actually do? Well, countries can use this as a method to try and resolve the problem of ensuring that their consumers are being supplied with safe food, whilst, at the same time, ensuring that strict health and safety regulations are not being used as an excuse for protecting domestic producers. Hurrah! And as we just saw, although there may be a small degree of overlap, the WTO SPS agreement is very much different from the CITES Convention, which protects wild and endangered species. The SPS measures relate to food and health, including animal feed and products. The SPS template is provided by the WTO, and is part and parcel of WTO membership. We see, WTO membership still allows countries to use different standards and different methods of inspecting products. It allows countries to set their own standards. But it also says regulations must be based on science. They should be applied only to the extent necessary to protect human, animal or plant life or health. And they should not arbitrarily or unjustifiably discriminate between countries where identical or similar conditions prevail. And there's more here, but what about other conventions or commitments? Okay, great. Jumping back to the border model. Scroll up a bit or search for page 24. And for exports, scroll up to or search for page 78. These two lists look similar, but they are not the same. Don't worry. I'm not going to examine the detail of each of these categories today. Note you can access all content via the table of contents at the start of this document. If any of these categories do relate to your business, then you will already be using the UK border model as a reference guide. I'm guessing the same again if you are using it for college studies. But if you are simply looking for something different to pass the time, then I hope my Tools Club videos can help you to more easily digest some of the content in this UK border model PDF download. If so, then hurrah. If not, my apologies. But enough of that. For now, I do want to quickly look at one or two differences between these two lists. Market surveillance, strategic export controls, and temporary export restrictions. What are these? Let's go right ahead and find out, you lucky people. So, standards. And right now, what do I mean by a standard? I found this guide for referencing standards in public procurement in Europe. Could be useful. Jumping to page 5. Standards are, in essence, an agreed way of achieving a set of objectives. Standards exist for a wide range of products and services in many domains, like toys, machinery, healthcare, construction, transport, energy, computing, and more, no doubt. And it is found that this sort of common understanding reduces costs in production, but also, it increases trade too. Cool. Keep that open for a moment. Back to the operating model. And so, exploring the relationship between market surveillance, EU directives and harmonized standards. We'll spend 15 to 20 minutes on this. Search for page 41. So, as we know, Rules to ensure food health for imports are adapted from WTO, Sanitary and Phytosanitary, SPS, rules. Market surveillance, on the other hand, deals with non-food imports. And prior to Brexit, this related to non-food imports, generally, from outside of the EU. After the UK transition period, from January 2021, non-food imports, coming to the UK, from outside the EU, as well as, from inside the EU, will be treated in the same way, by UK market surveillance. The activities carried out by UK market surveillance will now ensure that all non-food imported products, wherever they originate, comply with UK legislation. But still only shortly after Brexit. We see. Requirements. The legal obligations for the manufacture of products are those that are detailed in current EU legislation, which will be implemented in the UK and known as harmonized legislation. So, what is harmonized legislation and how does this apply to market surveillance? Okay, great. In this case, it seems the terms EU directives and harmonized standards have been abbreviated to harmonized legislation. Just for illustration purposes, and without going into too much detail, we'll explore EU directives and harmonized standards, and from the perspective of the European Union. To start with, one of the freedoms of the EU is that of the freedom of movement of goods. And we cover the free circulation of goods in the EU, elsewhere, but basically, if an item can be manufactured and sold in one member state of the EU, it can automatically be sold in all member states. But there are several issues that need to be resolved prior to free circulation in the EU. And a key issue is, how can the EU assure that any product, perhaps originating in one EU member state, will then be safe to sell and use in all EU member states? Well, to deal with this, and over time, the EU has identified key non-food product areas, and issued directives covering a vast range of products, in these non-food areas, where health and safety is of paramount importance. And we can see the areas covered by such directives, if we click here, to open the Harmonized Standards page of the European Union website. There will be safety, health or environmental requirements, expected, for products that fall under these categories. And we can imagine that any set levels of such requirements, will be a minimum, and non-negotiable. However, within a directive, there may be other articles, referred to as harmonized standards. And although harmonized standards vary in content, they are optional, and are chosen by manufacturers, as it best suits the design and manufacture processes of their particular product. But one common factor, applicable to all standards of a particular directive, is that they will all maintain safety, health or environmental requirements, as set out, elsewhere, within the directive. So, why are these standards called harmonized standards? And where do these standards come from anyway? So, very roughly speaking, we can imagine that countries of the EU maintain dialogue with business via technical bodies or technical boards. And, from these meetings, often driven by innovation, requests and proposals for new standards emerge. And from such requests, a proposal, or draft version of a new standard, is drawn up by experts, in the appropriate technical body. And as with the other standards, the new draft standard will be designed to conform to any fixed requirements set out in the parent directive. After the proposal stage, an inquiry process is started, and this is done by submitting the new draft version, and often via the European Commission, to all members of standards organizations, such as CEN, SANELEC, or ETSI, for analysis, comment and feedback. Next. My understanding is that, for example, with SANELEC, the membership is made up of different countries, and so, any new drafts are sent to these SANELEC member countries. From there, each country will pass on the draft standard to their manufacturers, public authorities, consumers, etc. for comment. The feedback is collated by each country, in order to form a national position for each country, on the draft version of the standard. A weighted voting system is adopted to succinctly interpret the national position of each country. If the results of the inquiry show 100% approval for the draft, then we can imagine, formatting and meta aside, that the standard will be published, probably as is. Otherwise, if there is not 100% approval, the technical draft is reworked and resubmitted to all SANELEC members. In this way, using comments and feedback from drafts and reworked drafts, and by using a weighted voting system, a final, internationally harmonized, standard, is eventually produced and published to the parent directive. As an FYI. 3 further points, also worth noting. First, that each harmonized standard is reviewed, at least, every 5 years, to ensure and maintain currency in these standards. Second, automatic adoption versus harmonization. What does this mean? Jumping back to Guide for Referencing Standards in Public Procurement, in Europe. Page 7. You may also see standards, referred to as EN standards. These are European standards that have automatically been adopted by the 34 countries signed up as members of CEN and SANELEC. On top of this, any previous version of a newly published EN standard is automatically withdrawn in these 34 countries too. However, only when European standards have been submitted by the European Commission to undergo the harmonization process, as we've very roughly described, can they achieve the status of harmonized European standards. Thirdly, page 11. We see a note on National standards transposing European standards. And we saw an example of this happening earlier, where the UK transposed EU legislation into UK regulations. And transposed legislation is identified as such. We see. Transposed legislation will be recognized as EU legislation, as these are implemented in all EU member states. When implemented nationally, a national prefix will be added. As an example, British standards are issued with the prefix BS in front of EN as BSEN. The same EN standard is issued in Germany as DIN EN. And in Bulgaria, it's given as BDSEN. And that's nice. Moving on. Back to EU harmonized standards. As we have seen, commonly, there are a range of harmonized standards for any particular directive. And all will be optional for manufacturers to use. Manufacturers may even design their own standards. But at all times, in this context, all standards must meet the mandatory levels of safety, health or environmental requirements, as set out by the directive. And in a nutshell, we see. A harmonized standard is a European standard developed by one of the European Standardization Organization CEN, SANELEC, or ETSI, on request of the European Commission. We also see. Manufacturers, other economic operators, or conformity assessment bodies, can use harmonized standards to demonstrate that products, services, or processes comply with relevant EU legislation. And that's nice. On top of this, before these non-food items can be released to free circulation in the EU, each product has to be marked with evidence showing that the product conforms to the appropriate EU directive. And there is what we might call a strict regime of product marking that has to be followed by manufacturers. And we can click CE marking and then manufacturers to find out more. Manufacturers follow the CE marking regime in order to demonstrate that their product complies with safety, health and environmental requirements as set out in the appropriate EU legislation. And we see 6 steps. Manufacturers have to identify the applicable directive or directives and harmonized standards. Also, verify their product-specific requirements. Next, it's worth noting that for products that present higher safety risks, such as gas boilers for example, safety cannot be checked by the manufacturer alone. In these cases, an independent organization, specifically a notified body, appointed by national authorities, has to perform the safety check. The manufacturer may affix the CE marking to the product only once this has been done. With that in mind. Point 3, we see. Identify whether an independent conformity assessment by a notified body is necessary. Some directives mandate that the manufacturer employs an authorized third party, i.e., a notified body, either to be involved in or to independently carry out a conformity assessment procedure, depending on the risks and dangers of a particular type of product. And this is necessary for a valid CE marking on the product. Fab. Next. Test the product and check its conformity. Manufacturers have the responsibility to carry out or outsource a conformity assessment procedure. And often, one is done in parallel to any independent assessment. This involves carrying out any risk assessments, as well as to test the product too. And by applying the relevant harmonized standards at this stage, manufacturers can directly prove conformity to the related EU legislation, and thus demonstrate that they fulfill the essential requirements of their particular EU directive. Next. Draw up and keep available the required technical documentation. Each directive specifies the technical documentation that manufacturers are required to maintain. These documents may need to be presented to authorities for the assessment of the conformity of a product to the relevant directive. Documents may also be used by authorities for risk assessment purposes. Lastly, we see that manufacturers or their representatives must affix the CE marking and draw up the EU Declaration of Conformity. The directives will contain rules relating to product marking. And we can also imagine that these rules probably cover a range of topics, such as visibility, legibility, permanency, size and location, packaging, if appropriate, as well as the details to be included, etc., etc. But on top of this, the CE marking does not mean that a product was made in the EU. EU directives, plus all associated harmonized standards, not only apply to domestically produced goods, but also to non-European imports, and all listed goods types, from anywhere, must obey the related directive, if they are to be sold in the EU. So, for manufacturers in the EU or outside, a CE marking indicates that the products have been assessed to meet high safety, health, and environmental protection requirements in order to be sold in the EU and EFTA states, or jointly, the EEA. On top of this, CE marking also supports fair competition by holding all companies accountable to the same rules. And that's nice. And manufacturers, from anywhere, must be able to present their technical documents to the authorities. But we see, included in this, manufacturers must also create and maintain something called a formal EU Declaration of Conformity. You may also see this, elsewhere, referred to as the EC Declaration of Conformity, or EC DOC. Fab. The EU, or EC, DOC. As you like, this also needs to be produced to the relevant bodies upon request. So, where does market surveillance fit into all this? Okay, great. If we imagine EU market surveillance, we can now understand that the product testing reports, as well as other technical documents required for valid CE marking, as well as the EC Declaration of Conformity, are tools to aid in enforcement of CE marking legislation, and to aid with checking compliance with the relevant EU directives. But interestingly, manufacturers may create their own standards if these meet the fixed criteria in the associated directive. And so, with this in mind, there is no single approach taken by market surveillance with regard to enforcement, and this very much depends upon individual EU directives and product lines concerned, as well as the level of cooperation between different authorities. But we can be sure that, by following a harmonized standard, given in a directive, and by maintaining the documents as specified in the related directive, this can go a long way to aid enforcement, making it quicker and easier for the authorities to validate the related products. So, what about UK market surveillance? Well, to reiterate from earlier, the legal obligations for the manufacture of products are those that are detailed in current EU legislation, which will be implemented in the UK and known as harmonized legislation. So, looking at this, we can understand that UK market surveillance, as with EU market surveillance, will check compliance with directives via goods marking and the associated documentation. And although manufacturers often create their own standards, we can also understand that by giving preference to the given standards in a directive, manufacturers can make checking and validation quicker and easier for the authorities. In this case, UK market surveillance, we see it is the job of market surveillance to check and ensure that all goods falling under directives meet the safety levels mandated in the directives. But UK market surveillance is not a single body. In fact, it refers to the activities carried out by market surveillance authorities to ensure products comply with the relevant legislation and do not endanger the health and safety of consumers and other aspects of public interest protection. But also, market surveillance in the UK is delivered by a combination of national, regional and local authorities, some of which are sector-specific, and others operating across multiple sectors. Organizations operating across multiple sectors may include Trading Standards Services, the Health and Safety Executive, the Medicines and Healthcare Regulatory Agencies, the Vehicle Certification Agencies, the National Measurement Office and much more, no doubt. And we can imagine that market surveillance have access to all manner of testing facilities too. And that's fab. It's also worth noting, if you are a distributor, you must check the presence of both the goods marking, plus any necessary supporting documentation. If you are importing a product that is from outside the customs territory, you have to check that the foreign manufacturer has undertaken the necessary steps to comply with the necessary goods marking. You must also check that the documentation, as set out in the directives, is available. And in both cases, the first document you might want to inspect is the Declaration of Conformity to UK regulations. But the UK now has its very own goods marking system. The UKCA Goods Mark. Hurrah! And we can imagine there are many similar parallels between UKCA and the CE Goods Mark of the EU. Both CE and UKCA marks indicate that the associated product has been assessed before being placed on the market. Both marks indicate the product satisfies the legislative requirements to be sold in their associated markets. And both marks mean that the manufacturer has checked that the product complies with all relevant essential requirements. But, jumping over to guidance, using the UKCA mark from the 1st of January 2021, and scroll down a bit, we see, whilst the CE mark allows the free movement of products within the European market, the UKCA mark allows free movement of goods within just England, Wales and Scotland. The UKCA marking alone cannot be used for goods placed on the Northern Ireland market, which still require the CE marking, or UK NI marking. A link to more help here. Scroll down a bit, and we see. You can start using UKCA straight away, but also, to allow business time to adjust, you can also use the CE marking if you're placing certain goods on the UK market until the 1st of January 2022. But also, we see a caveat. The CE marking will only be valid in Great Britain for areas where GB and EU rules remain the same. If the EU changes its rules and you CE mark your product on the basis of those new rules, you will not be able to use the CE marking to sell in Great Britain, even before the 31st of December 2021. So, worth remembering. But also, not all goods can continue to use CE marking in England, Scotland and Wales from the 1st of January 2021. Scrolling down a bit, to when to use the UKCA marking. And, in some cases, you will need to apply the new UKCA marking to goods being sold in Great Britain, immediately, from the 1st of January 2021. And this applies, if your product is for the market in Great Britain, and is covered by legislation which requires the UKCA marking, and requires mandatory third-party conformity assessment. And if your product conformity assessment has been carried out by a UK conformity assessment body and you haven't transferred your conformity assessment files from your UK body to an EU recognized body before the 1st of January 2021. What we might deduce from this is that with CE marking, the notified body carrying out any mandatory third-party conformity assessments, it seems, must be based in the EU. And for UK CE marking, the notified body must be based in GB. Anyway, just below that, we see this does not apply to existing stock. For example, if your good was fully manufactured and ready to place on the market before the 1st of January 2021. In these cases, your good can still be sold in Great Britain with a CE marking, even if covered by a certificate of conformity issued by a UK body. So, as we have seen, the UK has adopted EU directives and harmonised standards into UK legislation. And it will continue to maintain these directives and standards as UK harmonised legislation. But, just in case it's useful, we can see a list of relevant UK and EU legislation, side by side, at the bottom of the following page. Guidance. Placing manufactured goods on the market in Great Britain from the 1st of January 2021. We may revisit this page in future videos. For now, search for more information and scroll down a bit. Relevant UK and EU legislation. A handy list showing the EU legislation as seen at the end of 2020. And these are for specific goods types, but also given the title of the corresponding UK legislation and an email contact at the bottom. That's nice. So, to round off this section, standards promote common understanding in manufacturing, and as a result, they reduce costs in production, but also, they increase trade by allowing access to foreign markets. We have seen how directives have fixed rules, generally aimed at ensuring safety, health or environmental requirements. We have seen how standards bodies, such as CEN, Sanelec, or ETSI, are used to create these standards. And how applying a harmonized standard to your product also signifies compliance with the parent directive. But, by now, we might even understand that the international voting and reworking cycle of the harmonization process may even help to establish and propagate the directives in the manufacturing sector, but on an international level too. But the UK will now control its own set of harmonized legislation. And one might assume that UK harmonized legislation will be maintained in the same manner as EU and EFTA harmonized legislation. We might also assume that UK market surveillance will enforce these rules in a similar manner to European market surveillance. And how is that? Via goods marking, and the conformity documents and technical documents generated from the processes leading up to goods marking, as well as via market surveillance cooperation with sector-specific and cross-sector organizations too. And that's fab. So next. Strategic export controls and temporary export restrictions. Strategic export controls and temporary export restrictions. Okay, not to dwell. Strategic export controls. Search for page 122. First of all, what are strategic exports? Military machinery and weapons, but also dual-use goods. For example, firearms that could be used for both civilian or military purposes. But also, including other items, in connection with weapons of mass destruction, radioactive sources, and goods controlled, because of potential use in capital punishment and torture. Ouch. So, what do strategic export controls actually do? Strategic export controls. Many of these implement the UK's international obligations and commitments in the field of arms control and non-proliferation of WMD, and address international and domestic concerns about exports that can impact on conflict and instability, security, and human rights. But how are these controls affected by Brexit? The impact affects licensing of dual-use goods. Military goods always require a license to all destinations, including the EU, so we can put those to one side. However, dual-use and other controlled goods, with some exceptions, generally move license-free within the customs territory of the EU. Prior to January 2021, these only required licenses for export from the UK when moved to countries outside of the EU. But from the 1st of January 2021, a license will be required to export any and all dual-use items, even to destinations in the EU. If you, as a UK business or resident, already own export licenses issued by the UK, these will still be valid for export from the UK. Note, however, licenses issued by the UK will no longer be valid for exports starting from and moving out of the EU. And as we might expect, licenses issued by EU member states will no longer be valid for export from the UK. If necessary, you may wish to consult with the relevant authorities about the status of any EU-issued export licenses you might own. And we'll show the HMRC Import and Export General Enquiries page later, but you might get more information from here. Requirements. And for advice on export licenses, visit the Export Control Joint Unit. Quick skim. And links to more info on this page. Plus, contacts at the bottom. Okay, great. Temporary export restrictions. What are these? Just to the right. Temporary export restrictions that deal with shortages of supply. On rare occasions, any particular product might fall under export restrictions if they become, or are at risk of becoming, short in supply within the UK. On these types of occasions, any export restrictions will be temporary, but also announced on the gov.uk website. I found this page. Guidance. Exporting when there's a shortage of supply, temporary restrictions. How we will manage exports if there's a shortage of supply. Quickly skim through this. Could be useful. If you wanted to export such goods, at these times, you may be required to apply for a license. You would have to make a strong case when applying for such licenses, for example, goods are being exported solely for humanitarian purposes, etc. An export limit may restrict the volume of such goods at these times, or there may simply be an outright ban. And next, let's take a quick look at controlled goods. Okay, great. Typing 138 up here. And controlled goods. If you are an importer, check which goods are on the controlled goods list. If any of your goods are on the controlled goods list, you will need to complete full customs declarations from January 2021. But what are controlled goods? Things like excise goods. And excise goods include such products as alcohol, tobacco, fuels, etc. Also, controlled drugs. Precursors. Scrolling down, we see toxic chemicals. Ah yes, endangered species, either plant or animal. Looks like CITES stuff here. Fishery products with catch certificates. Fisheries is part of SPS stuff. But also, certain types of fertilizers, mines, explosives, firearms, military goods, various weapons, and more down here. Rough diamonds and more. But, if you like, get the latest information from HMRC guidance. So, let's do that. Take a quick look. List of goods imported into Great Britain from the EU that are controlled from January 2021. We see. You will need to follow normal import declaration rules for controlled goods imported into Great Britain from the EU from the 1st of January to the 30th of June 2021. Scroll down. This page links to more information on these items, letting you know what you need to do in the first half of 2021. Down a bit more. And jump back. Fab. So, a quick pause. And, as an aside, you may have noticed, we are now in the December 2020 UK border operating model. Released just in time to be used in this video, and the next one too. Hurrah! If you have followed all the previous videos in this mini-series, you might notice that the page numbers have now changed from those which you have seen so far. But that's okay. Doesn't slow us down. Okay, moving on. Page 138. Annex C. List of controlled goods, excluded from staged approach on import custom requirements. What does this mean? We see. From the 1st of January, traders must submit a full customs declaration, or use simplified customs declaration procedures if they are authorized to do so. They must use the customs process currently applicable, at the location that they are using, to move their goods, and ensure that any specific licensing requirements are fulfilled. And we have just seen the full list of import controls, on the UK government website. Scrolling down. And we see fishery products. And although, from the 1st of January, catch certificates, and processing statements, and storage documents, if applicable, will need to be submitted in advance of importing fishery products into the UK, there are additional staged controls for the fishery and live-by-valve mollusks category, plus the other SPS categories as well. And we'll look at these, as well as staged import controls, for other product types too. In our next video. The 2020 plan for the new UK customs border controls. For now, rounding off with the HMRC Imports and Exports General Enquiries page. Hurrah!